good morning to you. How's the mood like in US with the whole World Cup frenzy?
Good morning. We are excited. So I happen to be in Massachusetts, and that's where Ghana is playing the England. So you can only imagine we are excited. We have. If I knew you guys were going to wear your jerseys, I'll wear mine too. We have our jerseys. We are excited. We really look forward to supporting.
Absolutely. And maybe we'll definitely have you on Zoom again as Ghana progresses in the other games. And so you will definitely be wearing your jersey. So before that game happens, the one in Canada, we're hearing all this about Thomas Partey. I know you speak on U.S. immigration laws, but what do you just make of this whole situation of him being denied entry into Canada?
So countries always have a right to deny admission for a variety of reasons. Even if you have a valid visa, they always reserve the right to say that, okay, according to our specific laws, you do not meet XYZ specific criteria. So because I'm not bad in Canada immigration law, that's all I'm at liberty to say about it.
Okay, but for the U.S. immigration laws, what are some of the things that could bar a player from partaking in some of the games?
So my fellow panelists, and by the way, good morning, gentlemen, are perfectly right. When you fill the form, they go through it very critically, right? And then the first thing, for example, in the U.S. is that, did you answer the questions correctly, right? Is there any fraud or any misrepresentation? Also, is there any criminal issue? It's not all there's a criminal issue. Sometimes too, because there's an omission. So they look at these things too, and then they vet it thoroughly. For example, there was a referee, Omar, and then that he was not allowed to come in Miami. And CBP just said that due to vetting issues. They haven't said what exactly the issue is. What many of us are thinking is that they are concluding that he's linked to some terrorism things. However, things about these immigration systems, sometimes they don't tell you what exactly. They'll just be like, due to our vetting issues or due to our inadmissibility, due to X, Y. So yes, to answer your questions, based on a variety of issues, the U.S. can deem you inadmissible. For example, national security issues. We saw that a lot in the past, even regarding F1 students in the U.S. And the Department of State was like, oh, by the way, you posted something on Facebook a while ago, and then we think is linked to terrorism and all. So because of that, leave the U.S. or we render you inadmissible. It could also be criminal charges. It could also be because they think that you're going to be a public charge. I don't believe that's the reason in this World Cup specifically. But overall, if they think that you are coming to use the resources in the U.S., they may deem you inadmissible. It may also be for health reasons. So typically, there have always been a variety of issues of which the countries like the U.S. have stood upon to refuse people admission into the U.S., even if they have a valid visa. That's CBP's prerogative.
And this cuts across, I know maybe you may not have insights into Mexico's laws as well, but this cuts across about social media now playing a very vital role, in what people say, what they express, and that could deny you.
Absolutely, absolutely. Some time ago, there was a shooting in the U.S. some time ago, and then fortunately or unfortunately, one of the people, the person that actually did the shooting, the U.S. linked it to terrorist activities or national interest. So based on that, they really honed in on social media. As a matter of fact, some time ago, they made it mandatory for people that are applying for non-immigrant visas, such as B1, B2 for the World Cup, to make their social media not private, public, to make their social media public, so the Department of State can actually review their social media. So it does play a huge role.
Wow. I mean, we've had people warn us that, you have to be careful what you post on social media now. And if you've tried applying for the U.S. visa, as you mentioned, you see a column where they ask you to provide the social media handles, and so they definitely seem to be monitoring what your ideologies, what your thoughts are, what you want to act upon or not, and so that's good education. Thank you, Benedicta. Let's zoom into the big issue that's raging everywhere, not just on social media, but making news headlines, is the former finance minister who has been granted that green card approval, and the Office of the Special Prosecutor's cases that are still hanging around his neck. What does this even mean in layman legal terms that he's been given that green card visa?
Okay, so first things first. his immigration hearing or the giving of the green card does not interfere with the extradition at all. That is a separate legal proceeding than being granted the U.S. Than being granted a green card. The U.S. can give you a green card if you meet the eligibility criteria. In this case, his son, that was a U.S. citizen, petitioned for him. He got a green card through his son, adjustment of status. That has no bearing on the extradition case. What that means is that today, if the government of Ghana follows the proper channels and the proper forum, and they want to still pursue the extradition, they can do so.
Okay. Right. But, and what's interesting is that people are wondering, so no criminal charge or whatever charge it is affects them granting him the visa, the green card approval once a son has been able to petition for him to be granted that green card status?
Good question. So on the form I-485, that's the application for green card. They ask inadmissibility questions like, have you ever been convicted of any crime? And sources very close to me informed me that actually in court, the government attorneys, DHS, actually tried to raise this issue that, oh, there have been some criminal things and all. And then apparently the judge was asking them that, is there anything that has been properly filed in district court, or is there a conviction? And the answer was no. So that's one thing to say that the allegations of things, right? There's another thing to say, listen, I have properly filed in the proper forum X, Y, and Z. This is still currently pending, or there's been a conviction in a competent court concerning X, Y, and Z. As of the date of the immigration judge's ruling, that was not yet done.
That was not done in that district or in any other district or province in the U.S.?
That was not done in that. So there's a very specific way to do the extradition, right? You go through DOJ, you go through the district court. There's a very specific forum. The proper way to do it was not yet done. I'm not saying that it wasn't, they didn't attempt to do so.
Okay.
And I'm not saying that there were no talks of doing so. Now, in law school, we all take civil procedure, right? We take it in first year of law school here because there are specific ways of doing things. Me intending to do something and me following the proper procedure to do it are two different things.
Okay.
So at the time of the immigration hearing, the extradition request had not been properly filed with the adequate forum yet.
Okay. And so that's what, wow, that's what held it. But what can Ghana's lawyers or whoever is pursuing these criminal charges against him do in the interim? Because you have distinctly made it clear that whatever process they're doing to extradite him is not affected by this green card status.
Yeah, so it's not affected. And so if, for example, today they follow the right channels and they submit the right application, then the district court, that's the court of competent jurisdiction, would hear it. And if the district court decides that, okay, you have a case and then you've proven your extradition case, then they may continue to pursue it, even though he has a green card. So him having a green card does not give him a free pass, so to speak. If the paperwork is properly filed and a district court judge looks at it and reviews the information, because immigration court judges are just adjudicated immigration cases. They do take into consideration criminal history if, for example, there's a conviction or other things, right? But in this case, there was no conviction. So the judge is like, okay, this person's child has filed for him. Given the immigration criteria alone, it seems that this person is okay. Regardless of any criminal conviction or any extreme charge, or the government lawyers, of course, will try to argue the good moral character situation or a CIMT. They'll try to make all those arguments. They're just going to be like, okay, but do you have a conviction for me? Is anything properly filed now? Okay. If not, and based on what I have in front of me in immigration law, we are going. However, if these things are properly filed in the court of competent administration, that's the district court, it may proceed there.
Okay, has that been, if you can share with us, all learning and maybe students of law, because we get to talk to you. Has there been a historical antecedent of a case of this nature, and how do you anticipate it's going to end, or how did it end if there's been a case like that you have any knowledge of?
I don't have any knowledge of a case like that. However, we anticipate that if they file it the right way, in the right forum, we're anticipating that justice will prevail, right? We're anticipating that a federal judge in a district court would review the needed information, evidence that is brought before the court, and then they would proceed as they deem fair.